Hello everyone! One of the best and the most effective ways to prepare your case for a hearing before the State Personnel Board is to learn about the specific law that applies to your situation and to the accusations against you by the employer. And one of the best ways to do that is to look at the recent cases decided by the SPB, because they apply the same laws essentially to many, if not most, situations, and as different as every situation is, the fact patterns and the law that the agency applies, it's essentially the same over and over. So one very useful thing you can do is to pull out a few of those cases with similar accusations, look at the law, and try to figure out how you can argue that your conduct didn't quite amount to the violations under the law that the employer accuses you of, and therefore you should not be punished, or you should not be punished as severely as the employer wants you to. So, as an example, I pulled out one case with typical analysis and typical accusations, and I would like to demonstrate to you how you could use the law in this case in a typical hearing to your advantage. So, I'm looking at this decision, and I see that the first thing that the SPB almost always does is credibility assessment in their analysis. So they want to know who is more credible, especially when you have a he said, she said situation where the employee says one thing, the employer says the opposite thing. The judge doesn't know who to believe in, so they have to do a credibility analysis. So they say to resolve these conflicts in testimony, a credibility assessment is required using the criteria set forth under Evidence Code Section 780. So then the judge refers to the employer's witnesses as providing detailed testimony, nearly all of which was corroborated by other witnesses and written documentation. So you had a number of witnesses from the employer who essentially said the same thing, who supported each other's story, and who had some documents to prove that what they're saying is true. So of course it sounds convincing. On the other hand, the employee was difficult to follow. She repeatedly rehashed her complaints about these unrelated issues. She often went into long narratives that devolved into complaints about these other employees that have nothing to do with the situation, and she had to be redirected to answer specific questions several times. So she went off topic several times. Appellant was defensive and insistent through her own testimony. So what does it say to you? It says to you that the best way to testify in order to appear as you're telling the truth, which you should be, is to be direct, be to the point, be calm, not be defensive, and not talk about irrelevant things. For example, if somebody accused you, if your coworker accused you of something, talking about that coworker's own behavior in some other situation has no relevance to the accusation against you, so there's no need to talk about it. So, appellant was defensive and insistent. So if you become defensive, if somebody says that you did something wrong, and you say, well, she did something wrong too, and she's not all that great either, that's defensive, it's not on point, it doesn't address the accusation against you. Okay. Now, let's say you're accused of a very common violation, which is inexcusable neglect of duty. Under the law, in order to establish that, the employer must prove the appellant's conduct amounted to intentional or grossly negligent failure to exercise due diligence in performing a known official duty. So let's say you made a mistake at work, or you misunderstood your duties, or you tried to do your best, but the end product wasn't as great. You could say, look, I tried my best. I really did what I could. I thought I was doing the right thing. So even if I did something incorrectly or not of the highest quality, it wasn't intentional and it wasn't grossly negligent. Maybe it was negligent, but not grossly negligent, and therefore what I did doesn't quite amount under the law to inexcusable neglect of duty. So if you can connect the facts of your situation to show that they don't meet this high standard, this is going to be very effective. And it's going to be much better than simply saying, oh, it wasn't that big a deal, or coming up with some other excuses. Connecting the law to the facts is the best thing you can do, because that's what the judge is going to do anyway. Let's look at another common accusation, insubordination. A finding of insubordination is appropriate when an employee fails to submit to authority by intentionally and willfully ignoring or disobeying a direct order from a supervisor who they're supposed to obey. So, if you did not do something that your supervisor asked you to do, there could be all kinds of reasons, not because you intentionally did it. Maybe I forgot. Maybe I didn't see this email and I didn't realize that I was supposed to do this. Maybe I thought that this task was supposed to be done by someone else, not me. There's no evidence that I didn't do it intentionally or I on purpose ignored. I wasn't in the office to read this document or to read this email. These types of explanations are pretty legitimate and they undermine this whole argument of insubordination. Willful disobedience, another common accusation. In order to establish willful disobedience, an employer must show that the employee knowingly and intentionally, again, the same theme, knowingly and intentionally violated a direct command or prohibition. So, if there is evidence that you didn't do something right, it's much better not to deny something that happened, but instead say, look, it wasn't intentional. I wasn't going to benefit from not doing it. I didn't have any ill will toward anyone or toward my boss. This is the first time it happens. I always do the best I can. At most, it was an error in judgment. It was negligence. It was a mistake, but it wasn't on purpose, especially if there is no history of you doing the same thing. So if you're accused of anything, any other types of common accusations, such as discourteous treatment of the public or other employees or other failure of good behavior, find the law on SPB's website. Find the law that applies to your situation and apply that to your facts. And finally, let's talk about the penalty. The important part about the penalty that SPB is supposed to decide whether to impose or not is stated in the Skelly case, the Supreme Court case itself. We know that the overriding consideration in these cases is the extent to which the employee's conduct resulted in, or if repeated, is likely to result in harm to the public service. Other relevant factors include the circumstances surrounding the misconduct and the likelihood of its occurrence. So, if you work somewhere for 20 years, 15 years, even 10 years, whatever, this is the first time that something like this happens. You could say, look, it never happened before, and I promise you it will never happen again. There is no reason to suspect that it's going to happen again because it only happened once. I understand that what I did is wrong. I'll do my best to make sure it never happens again. Also, and the other factor is here is if repeated is likely to result to harm to the public service. Honestly, how big is your violation? How likely it is to result in actual harm? Did you misplace some documents? Did you mess up some insignificant numbers in accounting that resulted maybe in a few dollars being misallocated from one place to another? Or did you violate a serious safety regulation and you truly put public at danger? If you can make a legitimate argument that what you did was not that big a deal without sounding dismissive, if you can show that your mistake or your violation wasn't critical, this will also be helpful, if not completely removing your penalty, at least lowering your penalty, and the SPB finding that even though you may have engaged in a certain conduct that you're accused of, the penalty of dismissing you from your employment is too harsh and it should be reduced to something lesser. So, looking at the law and how it applies to your facts and tailoring your situation to the law to show why you don't deserve what the employer wants you to get is the best way to prepare your case, whether you represent yourself or whether you work with an attorney. Thank you.